A jury is a sworn body of people convened to render an impartial verdict officially submitted to them by a court, or to set a penalty or judgment. Modern juries tend to be found in courts to ascertain the guilt, or lack thereof, in a crime. In Anglophone jurisdictions, the verdict may be guilty or not guilty. The old institution of grand juries still exists in some places, particularly the United States, to investigate whether enough evidence of a crime exists to bring someone to trial. The jury system started in 5th century BCE ancient Greece, where members of the boule, or council, were selected from the male citizenry by lot. This process had two distinct advantages. Firstly, all citizens were considered for socio-political purposes to be fundamentally equal, and, secondly, the process prevented corruption. The boule were at the core of the original Athenian democracy. The modern criminal court jury arrangement has evolved out of the medieval juries in England. Members were supposed to inform themselves of crimes and then of the details of the crimes. The function was therefore closer to that of a grand jury than that of a jury in a trial. Etymology. The word jury derives from Anglo-Norman jure. Juries are most common in common law adversarial system jurisdictions. In the modern system, juries act as triers of fact, while judges act as triers of law. A trial without a jury is known as a bench trial. Types of jury. Petty jury. The petty jury hears the evidence in a trial as presented by both the plaintiff and the defendant. After hearing the evidence and often jury instructions from the judge, the group retires for deliberation to consider a verdict. The majority required for a verdict varies. In some cases it must be unanimous, while in other jurisdictions it may be a majority or supermajority. A jury that is unable to come to a verdict is referred to as a hung jury. The size of the jury varies. In criminal cases involving serious felonies there are usually 12 jurors. In civil cases many trials require fewer than 12 jurors. Grand jury. A grand jury, a type of jury now confined almost exclusively to federal courts and some state jurisdictions in the United States, determines whether there is enough evidence for a criminal trial to go forward. Grand juries carry out this duty by examining evidence presented to them by a prosecutor and issuing indictments, or by investigating alleged crimes and issuing presentments. A grand jury is traditionally larger than and distinguishable from the petty jury used during a trial, usually with 12 jurors. It is not required that a suspect be notified of grand jury proceedings. Grand juries can also be used for filing charges in the form of a sealed indictment against unaware suspects who are arrested later by a surprise police visit. In addition to the primary role in screening criminal prosecutions and assisting in the investigation of crimes, grand juries in California, Florida, and some other U.S. states are sometimes utilized to perform an investigative and policy audit function similar to that filled by the Government Accountability Office in the United States federal government and legislative state auditors in many U.S. states. Coroner's jury. A third kind of jury, known as a coroner's jury, can be convened in some common law jurisdiction in connection with an inquest by a coroner. A coroner is a public official who is charged with determining the circumstances leading to a death in ambiguous or suspicious cases. A coroner's jury is generally a body that a coroner can convene on an optional basis in order to increase public confidence in the coroner's finding, where there might otherwise be a controversy. In practice, coroner's juries are most often convened in order to avoid the appearance of impropriety by one governmental official in the criminal justice system toward another if no charges are filed against the person causing the death. When a governmental party such as a law enforcement officer is involved in the death, composition, Serving on a jury is normally compulsory for individuals who are qualified for jury service. A jury is intended to be an impartial panel capable of reaching a verdict. Procedures and requirements include a fluent understanding of the language, or the ability to test jurors' neutrality or otherwise exclude jurors who are perceived as less than neutral or more partial to one side or the other. Juries are initially chosen randomly, usually from the eligible population of adult citizens residing in the court's jurisdictional area. Jury selection in the United States usually includes organized questioning of the prospective jurors by the lawyers for the plaintiff and the defendant and by the judge, as well as rejecting some jurors because of bias or inability to properly serve, and the discretionary right of each side to reject a specified number of jurors without having to prove a proper cause for the rejection. Before the jury is impaneled, a head juror is called the foreperson, foreman, or presiding juror. The foreperson is sometimes chosen before the trial begins and other times upon the beginning of deliberations. The foreperson may be selected by the judge or by vote of the juries, depending on the jurisdiction. The foreperson's role may include to ask questions on behalf of the jury, to facilitate jury discussions, and sometimes to read the verdict of the jury. Since there is always the possibility of jurors not completing a trial for health or other reasons, often one or more alternate jurors are selected. Alternates are present for the entire trial but do not take part in deliberating the case and deciding the verdict unless one or more of the impaneled jurors are removed from the jury. In Connecticut, alternate jurors are dismissed before the panel of sworn jurors begin deliberation. Connecticut General Statutes 51-243 and 54-82H do not allow alternate jurors to be segregated from the regular sworn jurors. In civil cases in Connecticut, c. GS 51-243 provides that alternate juries shall be dismissed. Quote, "This differs from the power given to the court in criminal trials under c. GS 54-82H, permitting the court not to dismiss the alternate juries, and to have the regular jury panel begin deliberations. When an insufficient number of summoned jurors appear in court to handle a matter, the law in many jurisdictions empowers the jury commissioner or other official convening the jury to involuntarily impress bystanders in the vicinity of the place where the jury is to be convened to serve on the jury." Historical roots. The modern jury evolved out of the ancient custom of many ancient Germanic tribes whereby a group of men of good character was used to investigate crimes and/or judge the accused. The same custom evolved into the Wehrmacht court system in medieval Germany. In Anglo-Saxon England, juries investigated crimes. After the Norman conquest, some parts of the country preserved juries as the means of investigating crimes. The use of ordinary members of the community to consider crimes was unusual in ancient cultures, but was nonetheless also found in ancient Greece. The modern jury trial evolved out of this custom in the mid-12th century during the reign of Henry II. Juries, usually 6 or 12 men, were an ancient institution, even then in some parts of England. At the same time as members consisted of representatives of the basic units of local government, hundreds and villages. Called juries of presentment, these men testified under oath to crimes committed in the neighborhood. The Assize of Clarendon in 1166 caused these juries to be adopted systematically throughout the country. The jury in this period was self-informing, meaning it had very little evidence or testimony in court. Instead, jurors were recruited from the locality of the dispute and were expected to know the facts before coming to court. The source of juror knowledge could include first-hand knowledge, investigation, and less reliable source such as rumor and hearsay. John A. Makdissy argues that many concepts of English common law, including juries, at least partly derived from Islamic law. In the same period as William the Conqueror conquered England, Norman adventurers led by Robert Guiscard had taken Sicily, previously under the Arab Fatimid Caliphate. Thus, Makdissy claims, English law became influenced by the Islamic law used in Sicily under the Fatimids, including the use of the 12-man jury. Makdissy suggests that Henry II's laws would have been influenced through people such as Thomas Browne, a member of Henry's government who had previously served in the Sicilian government. Between 1166 and 1179, new procedures including a division of functions between the sheriff, the jury of local men, and the royal justices ushered in the era of the English common law. Sheriffs prepared cases for trial and found jurors with relevant knowledge and testimony. Juries found a verdict by witnessing as to fact, even assessing and applying information from their own and community memory. Little was written at this time, and what was, such as deeds and writs, were subject to fraud. Royal justices supervised trials, answered questions as to law, and announced the court's decision, which was then subject to appeal. Sheriffs executed the decision of the court. These procedures enabled Henry II to delegate authority without endowing his subordinates with too much power. In 1215, the Catholic Church removed its sanction from all forms of ordeal, procedures by which suspects up to the time were tested as to guilt. With trial by ordeal banned, establishing guilt would have been problematic had England not had 40 years of judicial experience. Justices were by then accustomed to asking jurors of presentment about points of fact in assessing indictments. It was a short step to ask jurors if they concluded the accused was guilty as charged. An early reference to a jury-type group in England is in a decree issued by Ethelred at Wantage, which provided that in every 100 the 12 leading thegns together with the reeve shall go out and swear on the relics which are given into the hands, that they will not accuse any innocent man nor shield a guilty one. The resulting Wantage Code formally recognized legal customs that were part of the Danelaw. The testimonial concept can also be traced to Normandy before 1066, when a jury of nobles was established to decide land disputes. In this manner, the duke, being the largest landowner, could not act as a judge in his own case. One of the earliest antecedents of modern jury systems is the jury in ancient Greece, including the city-state of Athens, where records of jury courts date back to 500 BCE. These juries voted by secret ballot and were eventually granted the power to annul unconstitutional laws, thus introducing the practice of judicial review. In modern justice systems, law is considered self-contained and distinct from other coercive forces, and perceived as separate from the political life of the community. But all these barriers are absent in the context of classical Athens. In practice and in conception, the law and its administration are in some important respects indistinguishable from the life of the community in general. In juries of the justices in Eyre, the bailiff of the 100 would choose 4 electors who in turn chose 12 others from the 100, and from these were selected 12 jurors. 18th century England. In 1730, the British Parliament passed the Bill for Better Regulation of Juries. The Act stipulated that the list of all those liable for jury service was to be posted in each parish, and that jury panels would be selected by lot, also known as sortition, for these lists. Its aim was to prevent middle-class citizens from evading the responsibilities by financially putting into question and the neutrality of the under-sheriff, the official entrusted with impaneling juries. Prior to the Act, the main means of ensuring impartiality was by allowing legal challenges to the sheriff's choices. The new provisions did not specifically aim at establishing impartiality, but had the effect of reinforcing the authority of the jury by guaranteeing impartiality at the point of selection. The example of early 18th century England legal reform shows how civic lotteries can be used to organize the duties and responsibilities of the citizen body in relation to the state. It established the impartiality and neutrality of juries, as well as reiterating the dual nature of the citizen-state relationship. Trial jury size. The size of the jury is to provide a cross-section of the public. In Williams v. Florida, 399 U.S. 78, the Supreme Court of the United States ruled that a Florida state jury of 6 was sufficient, that the 12-man panel is not a necessary ingredient of trial by jury, and that respondents' refusal to impanel more than the 6 members provided for by Florida law did not violate petitioners' Sixth Amendment rights as applied to the states through the 14th. In Brownlee v. the Queen 207 CLR 278, the High Court of Australia unanimously held that a jury of 12 members was not an essential feature of trial by jury in Section 80 of the Australian Constitution. In Scotland, a jury in a criminal trial consists of 15 juries, which is thought to be the largest in the world. In 2009, a review by the Scottish Government regarding the possibility of reduction led to the decision to retain 15 jurors, with the Secretary for Justice stating that after extensive consultation, he had decided that Scotland had got it uniquely right. Trials in the Republic of Ireland, which are scheduled to last over 2 months, can, but do not have to, have 15 jurors. A study by the University of Glasgow suggested that a civil jury of 12 people was ineffective because a few jurors ended up dominating the discussion, and that 7 was a better number because more people feel comfortable speaking, and they have an easier time reaching a unanimous decision. Integrity. For juries to fulfill the role to analyze the facts of the case, there are strict rules about the use of information during the trial. Juries are often instructed to avoid learning about the case from any source other than the trial and not to attempt to conduct their own investigations. Parties, lawyers, and witnesses are not allowed to speak with a member of the jury. Doing these things may constitute reversible error. Rarely, such as in very high-profile cases, the court may order a jury sequestered for the deliberation phase or for the entire trial. Jurors are generally required to keep the deliberations in strict confidence during the trial and deliberations, and in some jurisdictions even after a verdict is rendered. In English law, the jury's deliberations must never be disclosed outside the jury, even years after the case. To repeat parts of the trial, a verdict is considered to be contempt of court, a criminal offense. In the United States, confidentiality is usually only required until a verdict has been reached, and jurors have sometimes made remarks that called into question whether a verdict was properly reached. In Australia, academics are permitted to scrutinize the jury process only after obtaining a certificate or approval from the Attorney General. Because of the importance of preventing undue influence on a jury, jury tampering is a serious crime, whether attempted through bribery, threat of violence, or other means. Jurors themselves can also be held liable if they deliberately compromise their impartiality. Role. The role of the jury is described as that of a finder of fact, while the judge is seen as having the sole responsibility of interpreting the appropriate law and instructing the jury accordingly. The jury determines the truth or falsity of factual allegations and renders a verdict on whether a criminal defendant is guilty, or a civil defendant is civilly liable. Sometimes a jury makes specific findings of fact in what is called a special verdict, a verdict without specific findings of fact that includes only findings of guilt, or civil liability, and an overall amount of civil damages, if awarded, is called a general verdict. Juries are often justified because they leaven the law with community norms. A jury trial verdict in a case is binding only in that case, and is not a legally binding precedent in other cases. For example, it would be possible for one jury to find that particular conduct is negligent, and another jury to find that the conduct is not negligent, without either verdict being legally invalid, on precisely the same factual evidence. Of course, no two witnesses are exactly the same, and even the same witness will not express testimony in exactly the same way twice, so this would be difficult to prove. It is the role of the judge, not the jury, to determine what law applies to a particular set of facts. However, occasionally jurors find the law to be invalid or unfair, and on that basis acquit the defendant, regardless of the evidence presented that the defendant violated the law. This is commonly referred to as jury nullification of law, or simply jury nullification. When there is no jury, the judge makes rulings on both questions of law and of fact. In most continental European jurisdictions, judges have more power in a trial, and the role and powers of a jury are often restricted. Actual jury law and trial procedures differ significantly between countries. The collective knowledge and deliberate nature of juries are also given as reasons in the favor. Detailed interviews with jurors after they rendered verdicts in trials involving complex expert testimony have demonstrated careful and critical analysis. The interviewed jurors clearly recognized that the experts were selected within an adversary process. They employed sensible techniques to evaluate the experts' testimony, such as assessing the completeness and consistency of the testimony, comparing it with other evidence at the trial, and evaluating it against their own knowledge and life experience. Moreover, the research shows that in deliberations jurors combine their individual perspectives on the evidence and debate its relative merits before arriving at a verdict. In the United States, juries are sometimes called on, when asked to disobey a judge in the jury instructions, to make factual findings on particular issues. This may include, for example, aggravating circumstances which will be used to elevate the defendant's sentence if the defendant is convicted. This practice was required in all death penalty cases in Blakely v. Washington, 542 U.S. 296, where the Supreme Court ruled that allowing judges to make such findings unilaterally violates the Sixth Amendment right to a jury trial. A similar Sixth Amendment argument in Apprendi v. New Jersey, 530 U.S. 466 resulted in the Supreme Court's expansion of the requirement to all criminal cases, holding that any fact that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt. Many U.S. jurisdictions permit the seating of an advisory jury in a civil case in which there is no right to trial by jury to provide non-binding advice to the trial judge, although this procedural tool is rarely used. For example, a judge might seat an advisory jury to guide the judge in awarding non-economic damages in a case where there is no right to a jury trial, such as a case involving equitable rather than legal claims. In Canada, juries are also allowed to make suggestions for sentencing periods at the time of sentencing. The suggestions of the jury are presented before the judge by the Crown Prosecutor before the sentence is handed down. In a small number of U.S. jurisdictions, including the states of Tennessee and Texas, juries are charged both with the task of finding guilt or innocence as well as assessing and fixing sentences. However, this is not the practice in most other legal systems based on the English tradition, in which judges retain sole responsibility for deciding sentences according to law. The exception is the award of damages in English law libel cases, although a judge is now obliged to make a recommendation to the jury as to the appropriate amount. In legal systems based on English tradition, findings of fact by a jury, and jury conclusions that could be supported by jury findings of fact even if the specific factual basis for the verdict is not known, are entitled to great deference on appeal. In other legal systems, it is generally possible for an appellate court to reconsider both findings of fact and conclusions of law made in the trial court, and in those systems evidence may be presented to appellate courts in what amounts to a trial de novo of appealed findings of fact. The finality of trial court findings of fact in legal systems based on the English tradition has major impact on court procedure in these systems. This makes it imperative that lawyers be highly prepared for trial because errors and misjudgments related to the presentation of evidence at trial to a jury cannot generally be corrected later on appeal, particularly in court systems based on the English tradition. The higher the stakes, the more this is true. Surprises at trial are much more consequential in court systems based on the English tradition than they are in other legal systems.